The amendments I would look out for are, first of all, anything which might explicitly add to the list of treaties which are applied in national law, any or international law generally, explicitly trying to say that the withdrawal agreement or the trade and cooperation agreement don't apply, because that really does signal an indication explicitly. You could say it's already covered by the catch-all clause on international law. But to add to that, we are definitely going to say that in this area, we have no obligations under the withdrawal agreement, or, we'll just apply them under national law or under the trade and cooperation agreement, even though that's maybe not necessary. We won't, we're going to explicitly say that doesn't apply either. That sends a clear signal, especially if they're government amendments, that of a further breach of our obligations directly to the European Union, as the contracting party to either of those agreements. And of course, the point that Chris made about applying Section 7A, that would be of the Withdrawal Act, that would be, of course, disapplying our obligation to give effect to the withdrawal agreement in domestic law. Even if it's just limited to asylum issues, as I would think they would try and more carefully draft it like that, it would still be a breach of our obligation to give effect to the withdrawal agreement in domestic law, at least part of it, domestic law. So definitely be worried about that. And also be worried about whether they would get rid of or rather tightly narrow the possibility of hearing individual claims. One part that's still human rights compliant. So if they were to get rid of it or significantly reduce it, that's obviously a human rights law problem as well.